Yeah, welcome to the participants of the JCJ 2022, the main examination. And this is my online class. And today the class would be there. And tomorrow, no class. Again, we'll resume the class on 25th evening. And please read what I posted on the screen so that I could know that you are with me and I am with you.
Welcome to the aspirants of JCJ 2022 main examination for my online class, Civil Procedure Code 1908, Professor Dr. Mohammed Saheb Hussain, Professor of Law, SCIUT, Botswana, East
Okay.
Africa.
Yes. So that is the thing which I made it. In my last class, I was dealing about the. Did you have an idea? Say yes or no.
No, sir.
Okay. Last class that I was dealing about the foreign judgment. And a court which is given the judgment from the foreign court, it's all the foreign judgment. What is foreign court? A court other than the India is said to be the foreign court. So jurisdiction of the foreign court is concerned in private international law, unless a foreign court has a jurisdiction in the international sense, a judgment delivered by that court would not be recognized in India, provided I said the comity theory would be there. There is a comity theory. With that comity theory, what the comity theory says, I respect your judgment and you respect my judgment. That is the comity theory says. There is a reverence theory also we can say. So whatever the judgment would be the foreign court, the same judgment will be considered as a good in the Indian court. When the Indian court judgment would be there, they will consider also the foreign court as if it is a good judgment and they will be followed without any change in it. So that is called the comity theory. Sometimes the vested interest theory also comes over there. There are different theories would be there where the foreign judgment will be used as it is in India. You study this in the private international law. Have you studied the private international law? Answer is yes or no.
Yes, sir.
So that is there we will use the jurisdiction of the foreign court. So presumption as to the foreign judgments are concerned, section 14 states that presumption that an Indian court takes when a document supposing to be certified a copy of the foreign judgment is presented before it. The Indian courts presume that a foreign court of the competent jurisdiction pronounced the judgment unless the contrary appears on the record, but by proving one of the jurisdiction may overrule such a presumption. So, section 14, what is the presumption would be there? That a judgment will be by the competent court. That is the number one. And the judgment would be not in contravention with the local existing laws of India. And the judgment will not be in the contravention with the Constitution of India also. And the judgment would be not in contravention with the public policy. And such judgments could be used as it is in India. Is it clear?
Yes, sir.
Yeah. So that is actually the thing would be there. When section 14, presumption to the foreign judgment is concerned, the court shall presume upon the production of any document purporting to be the certified copy of the foreign judgment, and as it is, it can be used in India. So that is the presumption we will take in it. Then let us see the conclusiveness of foreign judgment. When the judgment is a conclusive, and when the judgment will be followed in India, foreign judgment I am speaking. Section 13 lays down the fundamental rules which not be violated by any foreign court in passing a decree or a judgment. A judgment should be fair, a judgment should be a natural one, a judgment should be based on the right, and such judgments will be followed anywhere other than India also or in India also if the judgment is given by the foreign court and that to be a competent court. The decree of the judgment of the foreign court will be conclusive except where it comes under any of the clause A to F of section 13. The A to F of the section 13 clear says if it is in contravention with the local laws or the public policy or the constitution, at the time it cannot be used as it is. and such a judgment is not binding on India. So that is the same thing which is made it clear in the foreign court will be conclusive, except there the condition is given is section 13 comes under any of these clause A to F. Now let us see the what is A to F. The same exceptions would be there. If you happen to see the CPC, you will see it now. Civil Procedure Bear Act. Is it visible? Is
Yes,
it
sir.
visible?
Yes, sir.
Good. So now I am scrolling to the section 13 because it is having the many acts. So let us see the where the section 13 will come. It is two definitions, and we'll go across 4, 5, 6, 7. Yeah, res judicata is 11. See, here is a 13. Read the 13. I said read.
Yes, sir. When judgment not conclusive, judgment should conclude
Yeah, your voice is breaking. Don't read. Don't read. Your voice is breaking. Don't read. I will read. When you say, when a foreign judgment not conclusive, a foreign judgment shall be conclusive as to any matter, thereby directly adjudicated upon, mute it, upon the between the same parties, between the parties under whom they are, or any of them claim litigating under the same title except number A, that is clause A, where it has not been pronounced by the court of competent jurisdiction. Suppose if it is not pronounced by the competent jurisdiction, it cannot be used as it is. Is it clear? Say yes or no.
Yes, sir.
Very good. Then mute it. Good. So number 1, that is a B, where it has not been given on the merits of the case. Yes, means if the merits of the case is not given over there, it cannot be a conclusive proof, conclusive judgment. And the C clause, and where it appears on the face of the proceeding to be founded on an incorrect view. It is the incorrect view of the international law or a refusal to recognize the law of India in cases where such law is applicable. So it is against the international law, or incorrect view would be there, or any law would be there in India, it is a contravention with it. At that instance, it is not a conclusive judgment. D, where the proceedings in which the judgment was obtained are opposed to the natural justice. If it is opposed to the natural justice, it cannot be a conclusive judgment. E, where it has been attained by the fraud. If the fraud is made in that judgment, it cannot be used as a judgment in India. F, if it is sustained the claims founded in the breach of any law in force, if it is in contravention with the public policy, in contravention with an existing law in India, at the time also, it cannot be used as a conclusive judgment. Is it clear?
Yes, sir.
Good. So that is the thing. When a foreign judgment is not conclusive, a foreign judgment shall be conclusive to any matter, thereby directly adjudicating upon the between the same parties or the between the parties under whom they are, any of them claim litigating under the same title, except what I said is section 13. See, the same thing is here. A, B, C, D, E, F. Am I right?
Yes, sir.
Yes, read the class A.
Where it has not been pronounced by a court of competent jurisdiction.
Yes, there is no competent jurisdiction. That will not be a conclusive judgment. Am I right?
Yes, sir.
So these are all the things would be there which is given. It is not the conclusive except where it is done on the A to F. Class A to F under section. Under section
13, sir.
13. Right. So the last one, where it sustains a claim founded on breach of any law in force in India. See, a breach of any law in force in India means if it is contravention with the existing laws in India. Is it clear?
Yes, sir.
Yes, that is the point in the section 13A to F is given. Foreign judgment, when cannot be enforced in India, before enforcing a foreign judgment or a decree, the party enforcing it must ensure that the foreign judgment or a decree must not fall under these 6 cases. What are the 6 cases? A to F. Is it clear?
Yes, sir.
A foreign judgment or a decree falls under any of these tests, it will not be regarded as a conclusive and hence not enforceable in India. So, it may be asked in the short question that you have to be clearly said that section 13 clause A to F, it clearly says if any judgment falls under it, it cannot be a conclusive judgment and enforced in India. Under section 13, there are 6 cases where a foreign judgment shall not be conclusive. Here says it shall not be conclusive, and 6 tests are discussed below. Of course, we discussed above also. So now we in detail we are giving it. Foreign judgment not by a competent court. When you say it's not by a competent court, that court doesn't have a power to give such a judgment. So it is a basic fundamental principle of law that the judgment or order passed by the court which has no jurisdiction is void. Thus, a judgment of the foreign court to be conclusive between the parties must be a judgment pronounced by a court of a competent jurisdiction. Such judgment must be a court of competence both by law of the state which has constituted it and in the international sense, it must have directly adjudicated upon the matter which is pleaded as res judicata. Res judicata. What is meant by res judicata?
The thing which is already decided by a competent court.
Yes. That court only having a jurisdiction, that case only having it can be ruled over there. Suppose that the High Court of Telangana or High Court of the Andhra has given the judgment, whether it will be a res judicata?
No, sir, because it is not a competent court to decide the matter.
It is a competent court in the state itself. Is it not?
Yes, sir. It cannot decide the other state matters.
Other state, it cannot be used over there. Suppose if you want to use other state,
Then Supreme Court is the competent court.
only the Supreme Court is the competent where the judgment will be used in any other court in India. That is the point we have to make it out. Now let us see the one of the case law, RMV Vellachi Achi versus RMA Ramanathan Shettiar. It was alleged by the respondent that since he was not a subject of the foreign country and that he had not submitted to the jurisdiction of the foreign court, there is a Singapore court, the decree could not be executed in India. So naturally, when the court is having a jurisdiction, at that instance only, the case should be adjudicated by using the foreign judgment. So, the decree could not be executed in India. The appellant, the defense of this argument stated that the respondent was a partner of a firm which was doing business in Singapore and had instituted a various suits in the Singapore courts. Therefore, the respondent had accepted the Singapore court jurisdiction. The court held that it was the firm which had accepted the jurisdiction of the foreign court and the respondent is an individual and capacity had not accepted the jurisdiction. It is a firm which is accepted the jurisdiction, but not an individual. Had not accepted the jurisdiction. Thus, High Court held that the decree against the respondent was not executable. If the firm partners would be there, but an independent who is the victim of it, he cannot be under the jurisdiction of the Singapore court. Is it clear? For instance, okay, I will give you another example. An Indian having a contract with the Tanzanian. You mute it, you listen. You mute it when listen. Yes, an Indian having the contract with a Tanzanian. What is the contract? Avocado. I don't know whether you know it or not. Avocado.
Yes, sir.
Yes?
Yes, sir. Avocado salad, avocado juice we can make.
Yes, avocado is mostly grown in Tanzania. I will show you the avocado. You will get it in India also sometimes, avocado. avocado images. It is very good. It is not. It is. It is like a papaya, but papaya is a tasty one. But it is the pulp. See, you cannot eat the seed. Seed is a big. You remove the seed, then you scoop it with the spoon and eat it, but not the cover. Are you following me? There is a contract with the supply of the avocado from there. And there in the contract, it is clearly written a person from India and another person from Kiswahili. If there is no agreement between if any case of the breach is there, in case of any breach, now the question comes over there, where the contract is signed. Suppose the contract is signed in India, or the contract is signed in the Kenya, or the contract is signed in Tanzania. At the time, there are laws are there which country is having the jurisdiction to entertain the case. Number one. In general, a person who is a victim of the contract and where his residence would be there, that forum shopping is given to that person. Means plaintiff where he is residing. For instance, in this case, plaintiff is from India, then Indian code is having a jurisdiction to entertain such case. But in the contract itself, it clearly mentions over there which law would be applicable, whether the Tanzanian law or the Indian law. Which one is having the more power? More wide in the laws?
India, sir.
Why? English law used in India first, and when it became the independent in the Tanzania by the colonial, at that time they are using the same Indian law over there, Indian Contract Act, Indian Civil Procedure Code, Indian Criminal Procedure Code, Indian IPC, and etc. etc. They are using at the time. And hence, law of India is wider than the law of Tanzania. And when there is no such a thing would be there, then the applicable law is India. Is it clear? And the Indian law can be used over there. And here the partnership is concerned. When there is a partnership is concerned, naturally, if it is only that firm, it could be applicable, but not the other people. So that is the only the thing which will be correct. So that would be the case law would be there. Okay, now let us see the another proposition. Under section 13, clause A of the CPC, the following proposition may be laid. In the case of the action in personam, a foreign court may pass an order or a judgment against an Indian defendant who is served with the summons, but he remains ex parte. But it may be enforceable against such an Indian defendant by fulfilling any of the following conditions. Now let us see that when contract in personam is there. If the person is a subject of the foreign country in which the judgment or decree has been obtained against him on prior occasion, that is the number one condition. B, if the person is a resident in a foreign country when the action is commenced over there. C, if a person selects the foreign court for taking action in the capacity of the plaintiff in which he is sued later. These all the terms and conditions are there. If the party on being the summoned voluntarily appears before the foreign court. E, if by any agreement person has contracted to submit himself to the court in which the judgment is obtained. So if these conditions are fulfilled over there, at that instance, foreign jurisdiction will be applicable, foreign law would be applicable, and foreign judgment can be applicable in India because it is clearly given in the terms and conditions. Is it clear? Is it clear? When the terms and conditions are clearly stipulated in the contract, and the same conditions could be applied when in the case of a breach. Is it clear?
Yes, sir.
Good. Now I will ask one question. A shipping contract between Kenya and Uganda. They can choose the law of any country, even though they are not party from the country. Is it clear?
Yes, sir.
They chosen the law of England, UK, because in admiralty jurisdiction, in admiralty court, the law of England is very much high, or wide, or big, or very developed when you compare with India also. So they have chosen the applicable law is UK or England, whatever you say, English law. Now the jurisdiction is concerned, both the Tanzania and Uganda have chosen the England, London. At that instance, if any breach will come, where the case will be filed?
In England.
It can be filed either in Kenya or in.
It is clearly mentioned in any case of the contract, breach would be there, jurisdiction is London.
Then London law only applicable.
And it is very much clearly mentioned there, the applicable law is London, UK, English law.
Yes, sir. If such condition is there, then that only applicable, sir. If no conditions are there, then any law of the country will be applicable.
Okay, no, nothing is mentioned anywhere in the contract. Now you tell me. Kenya and Uganda.
If such provision is not there, either country law will be applicable, sir. Either
There is
Kenya
a
or
procedure
Uganda.
that we lex loci. There is a lex loci contractus, lex loci celebrationis, lex loci actus. These are all the connecting factors are there. Where the contract is completed, or where the contract is signed, or where the contract is breached. These are all things will come, and that applicable law would be applied over there. Anyway, there is a private international law that you read in a wide manner, but for time being, there are connecting factors are there. Based on that thing, it will be given. But mostly the choice will be given to the plaintiff, because plaintiff is the victim. Is it clear? Forum shopping is given to whom?
Plaintiff.
Plaintiff. Because?
Was he the victim?
Yes. So foreign judgment not on merits. The second condition is, if it is not on merits, it cannot be implemented or executed or recognized in India. That is the same thing here. In order of the foreign judgment to operate as a adjudicator, it must have been given on the merits of the case. If the merits of the case, the decision is not there, it cannot be a conclusive judgment. A judgment is said to have been given on merits when, after taking the evidence and after applying the mind regarding the truth or the falsity of the case, the actual test of deciding whether the judgment has been given on the merits or not is to see whether it has merely passed as a matter of course, or by way of the penalty of any conduct of the defendant, or is based upon the consideration of the truth or falsity of the plaintiff's claim. So, if it is not in merit, it is not a conclusive judgment. Now let us see that. What is the read the case law? Read the case law.
In case of Gurdas Man versus In case of Gurdas Man versus Mohinder Singh Brahe, Punjab and Haryana High Court held that an ex parte judgment and decree which did not show that the plaintiff had laid evidence to prove his claim before the court was not executable under Section 13, Clause B of CPC, since it was not passed on the merits of the claim.
It is very clearly there. An ex parte judgment, it is not a merit of the case. Because by any other reason a party is not present, and the ex parte judgment you cannot make it out. Because the party will have a reason to vacate the ex parte. Am I right?
Yes, sir.
At the time, it cannot be a based on merit. Okay, when you say based on merit, trial was taken, evidence are proved, arguments are made, and the judgment is given by keeping the reason for the its claim for the reason for not claim. At the time, it is based on merit. Okay. Say yes.
Yes, sir.
Okay. Proposition 2. Proposition 2 means scenario. You know what is preposition and a proposition?
No, sir. Pardon.
Proposition means statement, scenario. Preposition means of, an, over, under, in, on. These are all prepositions. Spelling is
Preposition.
yes, that is the grammar preposition. And this preposition spelling is
Preposition.
Hmm. So under section 3B of the CPC of the following proposition on scenario may be laid a judgment or a decree passed by a foreign court against an Indian defendant who has remained ex parte may not be enforceable against him unless it can be shown that the said judgment was passed after the investigation into the plaintiff claim. So ex parte judgments are not based on
Not based on merit subject.
very good. Yes, welcome Sudha. Yes, I appreciate.
Thank you, sir.
Yeah.
Due to
Sure.
noise, I'm always unmuting my mic. Here,
Okay.
classes are being gone.
Okay. I appreciate. Because my tendency is there. If one student also there, I take my class because it is my instinct. Okay, let us
Yes,
come to
sir,
the point.
definitely. Yesterday was at relatives' home, so I couldn't attend.
Oh, it's all right.
It's nice
So-
to attend because I'm knowing many things other than
Okay. Whenever you get the time, please
definitely,
attend
sir.
it.
Thank
Okay. Now let us see the foreign judgment against the international or Indian laws. How it can be made it over there. A judgment which is contrary to the basic fundamental rules of the international law, as I told you, against the international instrument I made. So it is say against the international law or refusal to recognize the law of India. At that instance, is not a conclusive judgment. The law applicable is not a conclusive. Where a suit instituted in England on the basis of contract made in India, the English court erroneously applied English law, that the judgment of the court is covered by this clause, the general principle of private international law is that the right and liabilities of the parties to a contract are gone by the place where the contract is made. See, I told you earlier, lex loci contractus, where the contract is completed, where the contract is made, where the contract is signed. That is the connecting factor. What is the connecting factor here? What is the connecting factor here in the
where
contract?
the contract is made.
Lex loci contractus. It is a connecting factor for the contract. That means a contract where it is completed, a contract where it is made. But when you come to the marriage is concerned, the connecting factor is lex loci celebrationis, means where the marriage is conducted, the place where it is conducted. That is the connecting factor for the marriage. So these are all the comes in the private international law. Is it clear? Say yes. Sir, we don't know.
Yes, sir.
In India, private international law is not a core course. You know what is meant by core course? Yes?
No idea.
Core course means compulsory course, not elective.
Even
Is it clear?
the core, okay, sir.
See, this is African terminology. I am using it. In India, we use the different. It is not a elective course. It's a core course, means main course. Like IPS is the core course. Am I right?
Yes, sir.
Where refugee law is a elective course. International refugee law, international law of the land, not international court of justice laws, or any other thing which are electives. Some certain are core courses are there. Like human rights law, some places is a compulsory course. International human rights law is elective course. So now let us see the ING Investment Trust versus Raja of Calicut. A suit was filed under the English jurisdiction to avoid the consequences of the Orissa Money Lenders Act. What is the intention? To avoid the jurisdiction of the Money Lenders Act, the English jurisdiction is used. The court held that the judgment was passed on an incorrect view of the international law. So international instruments were violated over there or against the international law or instrument. The court further observed that although the judgment was based on the averment in the plaint that the Indian law did not apply, however, there was no refusal to recognize the local laws by the court. See, if it is no such a condition would be there, if it is not contravention with the local laws are there, at the time the judgment of the foreign court be used as it is. So that is the case. If it is contravention with the existing law, no conclusive judgment. If it is not based on merit, no conclusive judgment. It is based on fraud, no conclusive judgment. It is not based on the natural justice, no conclusive judgment. Is it clear?
Yes, sir.
Which section says?
Section 13 of CPC.
Section 13, class A to F.
Class A to F.
That clearly says which are conclusive, which are not conclusive. Now let us see the provision 3. Under section 3C of the CPC, the following provision may be laid. A judgment passed by a foreign court upon a claim for the immovable property situated in the territory may not be enforceable since the violator of the international law. See, what is the connecting factor for the immovable property? I think you
Where
studied
property
it.
situated.
There is a connecting factor for the immovable property. Lex locis situs, or we can say in short, lex situs. Spelling L-E-X, lex
Yes, sir.
space situs, S-I-T-U-S. Repeat.
L-E-S-S-I-T-U-S.
Lex situs.
R-E-S-S-I-T-U-S.
L-E-X, lex situs, space S-I-T-U-S, situs. So, where the property is situated for immovable property. Am I right? Am I right?
Yes, sir.
See, there is no dispute. Who is your mother? Am I right?
Yes.
But the dispute comes only
Then somebody denies it.
see in the same manner, there is no dispute for the immovable property because lex situs. For the movable property, there is a dispute. Because for the movable property, you know, what is the connecting factor? If you know it, you tell me. If you don't know it, you say pass on. For the movable property, it is lex domicili, means law of the domicile. It is a connecting factor in the private international law. Okay? Say yes. So a judgment passed by the foreign court where before a contrary Indian law had been shown, but the court had refused to recognize such law, then that judgment or decree may not be enforceable, except where the proper law of contract is a foreign law. So these are all the explanation from the section 13, class A to F. So foreign judgment opposed to the principle of natural justice. If any judgment opposed to the principle of natural justice, that cannot be used as that cannot be a conclusive judgment. So it is in the essence of the judgment of a court that it must be obtained after due observation of the judicial procedure, that is, the court rendering the judgment must observe the minimum requirement of the natural justice. It must be composed of impartial person who must act in a fair and justified manner, without any bias and a good faith. It must give a reasonable notice to the parties to the dispute, and each party should be given an equal opportunity to the present in their case. What is that maxim in the administrative law? Give the chance to the opposite party to
Adi
say.
altrum patent.
Repeat.
Adi altrum patent.
Adi altrum partem. Suppose the chance is not given to defense, it is against the natural justice. Because if any student comes late to your class, first and foremost, don't punish that person, the student. First, you hear what he says. If it is a excusable one, don't punish him. If it is a fabricated one, okay, you can punish him. Am I right?
Yes, sir.
So a judgment which suffers from such infirmities on the part of a judge will be regarded as a nullity, and the trial is a quorum non judice. Means it is not against the proper procedure would be followed over there. And that would be the idea behind it. Is it clear?
Yes, sir.
Good. So in the case of, it is gone. In the case of the Lalji Raja and Sons versus firm Hansraj Nathuran, the Supreme Court held that just because the suit was decreed ex parte, although the defendant was served with the summons, does not mean that the judgment was opposed to the natural justice. So it is very much clearly written, the Supreme Court, suit was decreed ex parte, although the defendant was served with the summons. Because when the summons are served to the defendant, it is a negligence on the part of the defendant not to attend the court, and hence a decree which ex parte would be given. It will not be against the natural justice. Is it clear?
Yes, sir.
Yes, because already summons were served to him. Okay. But he did not attend, then the ex parte would be there. This is not against the natural justice. The proposition 4 says, under the section 13D of the CPC, the following proposition may be laid. The foreign country must follow the principle of natural justice while delivering the judgment. So judgment must be impartial. Next, given fairly. Moreover, the parties to the dispute should be given a appropriate notice to the initiation of the legal proceedings, and equal opportunity of the presenting their case in order to avoid any allegation of not fulfilling the principles of natural justice in case the judgment or decree comes into the court, to the Indian court for the enforcement. Unless this is done, the judgment or decree passed by a foreign court may violate the principle of natural justice. So naturally, you have to give all the possibility of to defend himself. In spite of that one, if he could not do so, it is a negligence on the part of the defendant. Is it clear?
Yes, sir.
Good. Next, foreign judgment obtained by
Fraud.
fraud. If you do any fraud, naturally it is not a fair one. So it is a well-settled principle of the private international law that if a foreign judgment are obtained by the fraud, making the enforcement of the force or by means of any other, like a gunpoint, if they made the signature, and it will be a forcefully done. It will not operate as a res judicata because the judgment is made by the fraud. Hence, it has been said that the fraud and the justice never dwell together. Did you understand what it means? Fraud and justice never dwell together. Fraud is different. When a fraud is there, there is no justice. Am I right?
Yes, sir.
Then they never go together. Like frost et just non-cohabitant. That is the maxim where that say fraud and justice never dwell together. Two women never sit together silent. Am I right?
Maybe
The maxim, please, can you repeat, sir?
Two women cannot sit together without speaking for half an hour.
Men also won't sit together, sir.
Women never speak together. It is never happen. They know how do they make the conversation. Your saree is very good. Where did you purchase it? Or you say your earring is very good. Where did you purchase it? Even though they did not see each other and they are no more relatives also. Am I right?
maybe, sir, not always.
It is a universal truth. Okay, let us go to the point. Fraud and deceit out to benefit none. Even fraud and deceit, it will not bring the benefit to none. That is a fras et dulas ne minimis petriosinari debent. So that is the wording which is given over there. So if fraud is there, there is no justice. Is it clear? So in the case of the Satya versus Teja Singh, and the Supreme Court held that since the plaintiff has misled the foreign court as to its having the jurisdiction over the matter, although it could not have had the jurisdiction, the judgment and decree was obtained by fraud, hence inconclusive. If any judgment is made by the fraud, it is a inconclusive. So, SP Chengalwaria Naidu versus Jagannath, the Supreme Court held that. Yes, the Supreme Court held that it will well settle proposition of law that a judgment and a decree obtained by playing a fraud on the court is nullity and a non-stay in the eye of law. So if any judgment is obtained by the fraud, it is a nullity. It cannot be good judgment in the eye of law. Okay?
Okay, sir.
Okay, now read the proposition 5.
Proposition 5 under section 13
Yeah.
under section 13 clause E of CPC, the following proposition may be led where the plaintiff misleads the foreign court and the judgment or decree is obtained on that basis. The said judgment may not be enforceable. However, if there is some error in the judgment, then the Indian courts will not sit as a court of appeal to rectify the mistake or error.
See, when there is a judgment itself is based on misled one and it is made in the based on the fraud or not in the fair or not in the merit, and for that one the Indian cannot rectify it. They say either use it or throw it. When it is the wrong one, they can throw it, but they cannot use it. Is it clear?
Yes. Yes.
So foreign judgment founded on the breach of Indian law. In the Indian law, if any breach is there, foreign judgment, it cannot be a conclusive judgment. When a law in force in India is wrongly construed as to form the reasoning behind a judgment delivered by a foreign court, in such cases, the enforceability of the foreign judgment in Indian court will be under question. Definitely. Because it is construed in a wrongful way. When it is construed in the wrongful way, the judgment cannot be used in India. Is it clear? Then China Shipping Development Company Limited. Then the China Shipping Development Company Limited versus Lanyard Foods Limited. That is the case law. When this case law clearly mentions when the High Court held that a petition for the winding up of an Indian company would be maintainable on the basis of the judgment of a foreign court. In this case, the foreign company delivered a cargo to the Indian company in compliance with the request made by the Indian company, and in the process of the foreign company had incurred certain liabilities toward the third parties, and it has to pay the certain amount in the legal proceeding. Therefore, in terms of the letter of the indemnity issued by the issued by the respondent Indian company, the foreign company claimed the amount from the respondent Indian company, which denied its liability, and therefore the foreign petitioner company initiated the legal proceeding against the Indian company in the English court. Now let us see what happened as provided in the letter of indemnity. When the case is very much clear that letter of indemnity will be given by the respondent petitioner, at the time it is a binding one. Am I right? Read what is given here. Read it. The respondent Indian company. Read.
Respondent Indian company did not defend and passed an ex parte order awarding a certain amount in favor of the petitioner foreign company on consideration of evidence and merits of the claim filed by the foreign company by a notice issued under section 433 and 434 of Companies Act 1956. The petitioner foreign company called upon the respondent Indian company to pay the amount due under the order of the English court.
See, when it is indemnified, it is there in the contract. At the time, it is a must of the foreign company, Indian company, to pay the amount, indemnify the third person. After the respondent Indian company filed the amount, the petitioner foreign company filed a petition for the winding up of the Indian company. In the above circumstances, since the records of the case manifestly revealed that the respondent Indian company was unable to pay its debts, the petitioner for winding up was admitted by the order dated 4/4/2007 under section 433 and 434 of the Companies Act 1956. When the Indian company indemnified it, in that instance, Hosea, mute it. Hosea, mute it. Hosea, mute it. Yes, good. So when you indemnified by the foreign company, that is Indian company, at the time, they have the every power to file a case of finding out, because it is clearly mentioned in the contract. I gave this handout to you in advance. The purpose of giving in advance is to, sir, we did not read it. Proposition 6. Under section 13F of the CPC, the following proposition may be laid. A judgment passed by the foreign court which breaches any law in force in India may not be enforceable, except where it is based on a contract having a different proper law of the contract. I don't know how far that you got it, this point. What the section 13, class F of the CPC says? A judgment passed by a foreign court which breaches any law in force in India is a conclusive judgment?
No, sir.
They clearly says, if any judgment in contravention with the existing laws, number 1, in contravention with the Constitution, number 2, number 3, in contravention with the public policy, number 3, in contravention with the international instrument, number 4, if it is by fraud, or number 5, these are all things that you have seen from section 13 to class A to class F. Is it? Enforcement of the foreign judgment. A foreign judgment which is conclusive does not fall within the section 13A to F may be enforced in India in either of the following: by instituting the execution
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा चञ्चल जलधि तरङ्गा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full